cartels and collusive activities. And this sort of behavior, that sort of behavior, tends to be the paradigm of the conduct which any competition or antitrust regime wishes to control. Okay? Collusive agreements to fix prices, allocate markets, rig tenders, reduce outputs. These all, A, are harmful to the consumer, and B, have no countervailing, have no balancing advantages. Now, a couple of things. First of all, the harm need not be done directly as an agreement. Information sharing and passing of information can also be as harmful as an out-and-out cartel type agreement. Information sharing, the leading case on information sharing, the most recent case on information sharing is the T-Mobile decision, which I think we discussed when we talked about concerted practices. In T-Mobile, you remember that was the situation where you had a group of marketing executives for the cellular companies, the mobile companies in the Netherlands, and the T-Mobile representative indicated that in the future they were going to be reducing the commission paid to those who sold T-Mobile contracts. That was held to be a breach of Dutch and EU competition law, and T-Mobile was, as a consequence, was fined. Another sort of information sharing, equally as pernicious, is a hub and spoke, or sometimes known as an ABC cartel. This is where you have a situation where you might have dealers of a particular product and information, so A and C may be dealers or retailers of a particular product, and B might be a distributor. And A's intentions is passed to C through the conduit, through the pipeline of the dealer B. Okay, this is a very common form of practice. For some bizarre reason, it seems to be more common in the UK than anywhere else. The dairy industry, about 8 or 9 years ago, was doing this to funnel prices of milk. And about a decade or so ago, the board games industry was doing this. I don't know, it's very common in England, I guess, around the December period for people to spend time playing board games. It's not the only time they do it, like, Clue, Monopoly, or whatever. One of the reasons I hate visiting my relatives around this time is because you sit down for an afternoon and torturous board games. But what was happening is two of the larger retailers, Argos and Littlewoods, which is now something else, were passing their December sales strategy through the distributor, Hasbro, the maker of the board games, okay, and sort of coordinating pricing and marketing information. So as opposed to competing, they were sharing information about prices and about how they would market these games. Ironically, one of the games in question was Monopoly, which is a fairly interesting thing. Now, suppose you're participating in a meeting, or your client is participating in a meeting, or someone's participating in a meeting, and this information is shared. EU law is very clear. Okay, we've got the Denki Kagu case. We've got a later case of T-Mobile. That if you are participating in a meeting, or if someone is participating in a meeting, okay, as a representative of an undertaking, and which agreements of an anti-competitive nature were concluded, or related to T-Mobile information is shared, then it can be concluded, or there's a presumption, that those attending the meeting were there for the same purpose, to share that information or to conclude that agreement. Okay? So it's a presumption that if you're attending a meeting and cartel things are being discussed, you're part of the cartel unless so the burden shifts to the person attending the meeting or the undertaking whose representative attended the meeting, unless you can establish that you were there for a different purpose and you immediately distanced yourself from the illegal or the anti-competitive intention that everybody else had. Okay? How do you do that? How do you distance yourself from that anti-competitive intention that everybody else has? Okay? Well, there's a number of ways of doing it. Okay? You immediately indicate to your competitors that, hey, it was not my intention to attend the meeting to discuss cartels. Okay? And even silences, you have to immediately speak out. Okay? Needs to be firm and unambiguous disapproval. Okay, so what you do, okay, and this is important, is you in effect get up, walk out of the meeting saying it is not my intention to participate in cartel or cartel-like activity. Sort of immediately send everybody else an email, but more importantly, inform the competition authorities. Okay? Probably inform your legal team first, who should then inform the competition authorities. You will see from what we will discuss that the competition authorities, if you're the first person, the first undertaking to inform them of potential cartel activity, you will be immunized. There's no fine. The fine will be waived. Okay, so it's in your interest to do this. Now, why is this important? It's important for two reasons. First of all, if you are a practicing competition lawyer, you may be called on to do antitrust or competition compliance work. That is to say, give talks, lectures to people in undertakings, in firms that may be attending such meetings with their competitors, telling them what they can and can't do. Secondly, you may be corporate counsel, in-house counsel, who's faced with a problem that one of the sales people says, I was at this meeting yesterday and this was discussed. What should I do? Oh, geez, you need to do this, this, and this now. Okay? So keeping that in mind is important. Okay? Furthermore, also if you're doing competition defense work or antitrust defense work, if there's an issue, and a week later or 2 weeks later, you find out there's a problem, then you've got a whole bunch of other mitigation that you have to put into place. To get to the relevant authorities and hope nobody else is beating you. Okay? Yes.
Quick question. So if we just go to the scenario of like the trade association in Vegas, where like you have all of those big players, and this sort of happens.
Yeah.
Wouldn't one fear of notifying the authorities is if all those people are such huge players, they'll just push you out of the market for like, you snitched on us, sort of. Why would you do that?
Why would you do that?
Everything, we're going to kick you out of the market.
Well, you can, okay, yeah, I mean, why would you do that? Why would you do that? Because you're not going to be fined, okay? they'll be fined. Okay? Fairly simple. You're not fined. That's your legal duty. If you don't want to conform with your legal duty, then you take the risk. Then you join the cartel. And then as a participant, you join the cartel, you have no defense. Okay? But if you're a lawyer, you can't encourage, you can't condone illegal activity by your client. Right? You have to tell your client, no, this is your legal obligation. If you're outside counsel, okay, and your client comes to you for advice and says, well, and you say you have to turn them in, they say, well, but I don't want to because it's going to, it might have commercial implications for me. Well, my advice is you turn yourself in. And if they don't want to heed your advice, you probably need to write them a strong letter and then reconsider whether you want them as a client. Okay? The Vegas example is actually very interesting because of the consequences of an antitrust violation in the US. Quite often, they will send a legal team or legal representatives along with the sales representatives to these sorts of conferences to monitor what was going on. In fact, you don't go out without you don't go for drinks unless you're lawyered up, i.e. with a lawyer, to ensure the conversation doesn't drift into potentially criminal matters. Okay? In the EU, not so much. Okay? Information, so the thing to do is clear and unequivocal distancing. Send everybody an email, inform the commission, or now both the CMA and the commission. Okay? There's in fact, if you look at the commission's website, the same with the CMA's website, you'll see report a cartel. And there's now an email address where you can email the commission about the details. It used to be a fax machine. Technology's moved on. It's email now, okay? And, the first, about 2 or 3 years ago, I think we stopped using fax. So technology's moved on, but not that fast, okay? And it's usually, the first email through wins in a leniency, as we will see shortly. Is that a question?
How would the EU sort of then treat whistleblowers in the sense that one of the employees notifies the commission or the cartel?
That's what they're looking for. Most cartels in the EU are uncovered because of whistleblowing. Okay? Typically what happens is somebody reports. Okay? And the reason somebody reports is they do the right thing, they're at a meeting, there's a change in management. Management says what was going on in the past no longer works, so they're doing due diligence as a result of a potential takeover. Okay? Very many sort of social reasons within the undertaking as to why that happens, but most cartels in the EU are detected as a result of information provided by an employee of one of the participants. Okay? The EU's leniency program, and we'll get to that, sets that up quite well. Okay. Information exchange. Information exchange can be very problematic. One of the leading cases is the John Deere case. Okay, this involved, the John Deere tractors, those green and yellow tractors that you see. You seen those? No. Okay. That's big farm, for farms, agricultural tractors. Okay. Now, what was happening with in the John Deere case is that the dealers in the UK were sharing information and this information was broke down to the postcode level. okay? Individual postcodes about where tractors were being purchased, okay? And yes, so we know that in a particular postcode, a tractor was purchased, okay? And this information was then shared to all dealers in the UK. Okay, now, you may not know that in the UK, postcodes are fairly specific, right? You can probably send a letter to somebody by putting their door number and their postcode. You know, if you do that, to me, it will get there, because if you live in an area, postcode specific. In many cases, an individual farm might have its own postcode, different from the farm adjacent to it. Okay? Now, this information exchange, so can you see the problem there? Okay? Suppose you wished to organize a cartel that allocated territory in the UK. In other words, I'll sell to the farms in Cumbria, you sell to the farms in Lancaster, they can sell to the farms in Northumberland. Okay, say county by county, right? If you know who's buying the tractors, you would also have the information which allows you to police whether or not somebody in an adjacent area is selling tractors in your territory, right? So if you, for instance, sell tractors only to farms in Cumbria, you look up all the postcodes in Cumbria. Ah, wait a minute, I sold 63 tractors to Cumbria, but 64 tractors have been sold. Ah, somebody sold a tractor to somebody that they're not supposed to sell. So that's how you police that cartel, right? With that information.
Yes. Is that kind of resource allocation?
That's a geographic allocation. Okay. The cartel by sort of allocating territory. Okay, which is equally as bad, because what you're doing is you're saying somebody has a monopoly in Cumbria, somebody has a monopoly in Lancaster. Okay? So John Deere, okay, so this information allowed the John Deere dealers to insulate themselves from the rigors of competition. Okay? And what it does is it reveals to everybody the various strategies of all players in the markets. So rather than there being some necessary opaqueness or unclarity, this sort of information sharing allowed for a completely transparent market. Okay, and it was wrong because it reduces or even removes the uncertainty of competition that would have existed in the absence of this. Now remember, the first hour of yesterday's lecture, when I discussed Generics UK, one of the principles of EU competition law is that each undertaking has to choose its own competitive strategies in the market. The second principle is that there needs to be, okay, or that there should be some uncertainty about the market behavior, particularly of other undertakings. Removing this market behavior, removing this uncertainty, okay, makes it easier, makes coordination easier, and therefore prevents each undertaking from determining its own conduct on the market. So this information exchange removes the uncertainty necessary for effective competition on the market. Okay.
I'm struggling to understand the purpose for like cartels like these, because it seems like most of it's not like, so it's not usually like a car dealership that sells a wide array of cars. It seems to be just one specific company selling their own products. Why is there a need to allocate the market? If you're only selling my products,
Right.
why do I care? Because at the end of the day,
Okay, hang on.
same amount of stores.
Okay, John Deere doesn't care, but John Deere's dealers care.
Okay.
Okay, and John Deere. Okay, the bottom line is John Deere doesn't really, to a certain extent, only cares about how many tractors are sold in the UK, the sum total of tractors. Okay, but in order to sell tractors, John Deere needs dealers to sell tractors. So it needs to keep its dealers happy. Okay, now, two things. Quite often, these sorts of cartels, okay, are driven by the dealers. So the dealers have decided to insulate themselves from competition from other dealers. Okay, and have asked or put pressure on John Deere to find ways to assist them in maintaining this cartel. This may well have been one of the ways, okay? We want to form a cartel. What we want is we want a geographic monopoly. Okay, so I want Cumbria, you can have Lancaster, they can have Northumberland. Okay. We don't want, but we also want a way to police this geographic monopoly, because there's inherent suspicion that somebody else will be poaching. Okay, so we'll put pressure on John Deere to give us the sales information in the form of this information exchange. Okay, so that we can police our little cartel, or actually our big cartel.
So then in these cases, what is sort of the consequences for the dealers themselves? Because I can see John Deere is fine. What about the dealers themselves?
The dealers themselves are fine because they don't have to worry. They've got their own territory. Okay, so they're given a geographic monopoly.
Well, how's the competition already deal with the dealers? Because is it just like in cases like these where it's driven by the dealers, is it just the parent that's sort of found like John Deere here, you're fine, you gave the information.
Right.
But if it's the dealers putting pressure on the parent, are the dealers fined as well, or just?
Yeah, everybody's fine.
Oh, okay.
Okay? Everybody's responsible. It becomes a form of hub and spoke,
Okay.
right? Everybody's responsible. Okay? Okay, now not all parallel conduct and all parallel pricing is necessarily, or information exchange is necessarily a breach. This is the wood pulp 2 case. Remember we talked about the wood pulp case? The two aspects to the wood pulp case. The first one is the jurisdictional aspect, and that is to say that a cartel, even if it's formed outside of the European Union, if it has an effect upon the European market, it breaches European Union law, right? We mentioned that. Same principles apply to U.S. law, so on, so most other countries, antitrust laws. Okay. The second aspect to the wood pulp had to do with parallel pricing. Okay. In this case, the wood pulp manufacturers made quarterly price announcements every 3 months to take effect several months down the line. Right? Remember this? Okay. And the whole idea was that this would allow for their customers and their customers' customers to take into account the pricing intentions. Okay, and these were apparently requested by the customers. So there was a possible alternative explanation. Now there was a commercial justification or a commercial defense for this activity, and therefore the European Court of Justice held that there was was no breach of the cartel provision here by sharing of this information when there was a commercial need for it. Okay. Now, here, a couple of other points. Cartel facilitation. Okay. The Treuhand case. This is a really cool case. Okay. Treuhand was a Swiss company. Is a Swiss company. And this cartel involved soybean, tin stabilizers and soybean esters. I have no idea what the whole relationship is. But anyway, you've got a couple of industrial cartels. Okay? Treuhand wasn't a producer of these products. Treuhand wasn't really a party to these agreements. Treuhand was, in effect, a cartel facilitation service. Okay? You subcontracted the running of your cartel to Treuhand. Okay? Treuhand would organize the meetings, you know, book the hotel suites, get the catering. Okay? Treuhand would collect and supply the sales data, the marketing data for the markets. If there was a breakdown in relations between cartel members, Treuhand would try to mediate a solution. Okay? Find compromises, so on and so forth. Okay? Treuhand would, of course, take a fee. A nice fee. Okay? Now, it is what Treuhand did illegal. Okay? Treuhand said, no, what we're doing is perfectly fine. Okay? The court, and it's perfectly fine, according to Treuhand, because in 1957, when the treaty was written, nobody would have any idea that this sort of activity was possible. Therefore, it couldn't have come into the contemplation of those who drafted the treaty. Therefore, what we're doing is not covered by the treaty, therefore it's perfectly legal. That was Treuhand's argument. Buy that? You think that's a good argument? No. Okay? Key thing is, remember how the European Court of Justice reads the treaties. So what's known as a teleological interpretation. That's to say a goal or an end oriented. What's the purpose of the treaties? So we read the treaty's provisions in accord with its goal or purpose. If you bought Treuhand's argument, that would completely frustrate the goal of the treaties, right? The effectiveness of the treaties would be diminished. Okay? So now there's some interesting discussions in that. Okay, the very purposes of what Treuhand was doing ran afoul of the treaty. There's some interest in 39 through 45, with Treuhand's argument in mind. Basically, the court says something like, you know, you say to a small child when they've done something wrong, sit down in the corner and think about it. You'll soon come to a realization that what you've done is wrong. And in fact, that's what the court says to Treuhand. Had Treuhand reflected on what they were doing, they would have certainly known that this practice was illegal. Okay, so the court fined Treuhand rather severely. I don't know if they're still in business doing what they're doing. The other case, and other interesting cases, involve liability for parent and subsidiaries. We talked about that earlier when we talked about the notion of an undertaking. The other problem is not just a parent and subsidiaries, but what about a company that hires a subcontractor. A completely separate undertaking hires a subcontractor, and that subcontractor gets involved in anti-competitive activity. This happened in Raymont. Okay. The solution is that the Advocate General proposed was that the general contractor should be responsible for the subcontractor's anti-competitive activity if the general contractor benefited from it. Okay. And the presumption should apply. Okay. However, this was one of the cases where the court disagreed with the Advocate General. Okay. This is what the Advocate General said. There should be a presumption that the general contractor is responsible for the subcontractor's misdeeds, but the undertaking can rebut it. And in using the Troyan test, the Advocate General suggested that public distancing was necessary. Okay, using various case law. But the court disagreed, okay, and came up with a decision that because the subcontractor is independent of the general contractor, we can't ascribe liability. So it takes a very narrower reading, okay? Argues that the control of the subcontractor is very different from the control of the general contractor. Okay, if there was close connection, then it's one and the same undertaking. In the absence of close connection, it isn't. Okay. So the court says that generally speaking, in the absence of close direction, or in the absence of there being one undertaking, a general contractor is not responsible for the sins of its subcontractor.
In the absence of close what?
Of close direction.
Okay.
Okay? In other words, where the subcontractor had no alternative but to act in the way. Okay, so you can look at that if you wish. Now I'm going to turn to the EU's enforcement of the competition provisions. Okay. As I pointed out last time, enforcement of 101 and 102 in the EU by the Commission is administrative only. Okay? It's administrative only in the UK, except when a hardcore cartel is involved. Okay? The EU does not have criminal jurisdiction. There's no EU criminal code, no EU criminal penalties, there's no EU jail. Okay? Furthermore, in the EU, according to Regulation 1/2003, fines can only be meted out to undertakings. And the Commission tends to avoid fining individuals. Okay? I think there's been one case of a sole proprietor, an individual, being fined under EU competition law, and there was a very nominal fine of equivalent of €100 or something like that. Okay. The EU is reluctant to fine individuals. Now, one of the main investigative tools, okay, versus an intelligence tool, okay, as I said earlier, The main source of information about cartel activity comes from usually some whistleblower. Okay, there's a meeting, there's a change of management in the company, et cetera, et cetera. So what happens is somebody informs the commission takes this information and then uses it to investigate the matter. If you're one of the firms attending the meeting and you blow the whistle, you tend to turn over notes, information, emails, etc. to the commission, provide them the information, and then the commission starts investigating and building a case. Sometimes the commission, particularly in cases where there's some serious bad activity going on, they don't want to tip off other undertakings that there's an investigation going until the last minute, because of course there's an incentive to destroy things. Commission has the power to inspect premises, business premises. Okay? The same power, the CMA has the same powers in the UK. It has the authority to enter any premise, lands, and means of transport, examine books and other records, take copies, seal any business premises or books. Okay. The reason you would seal business premises and books, okay, this is known as a don raid. The reason you would seal business premises and books so that you can come back the next day and continue your investigation. The commission has hologram type seals that they put on doors to ensure that they haven't been opened. If you break a seal, there's a problem. There's a case where a member of the cleaning staff broke the seal. The undertaking was responsible, had to pay, I think it was in the millions because of that. Okay? This is another part of cartel defense. When the commission people show up, or the CMA shows up, and usually first thing in the morning, not because, the reason the cops break into a drug dealer's house first thing in the morning is usually the drug dealer's asleep. But the reason the commission shows up for a dawn raid first thing in the morning is it gives them the rest of the day to do so. So you're a competition lawyer. You get a call at 8 o'clock in the morning, like somebody saying that there's somebody down at the reception desk saying that there's some people from the commission showing me a document, and they want to come and search everything. What should I do? Answer is let them do what they want. I'll be there as soon as possible and be cooperative. That's the answer. Okay. Inspection powers, they can ask any representative to clarify anything in the facts in the documents. Furthermore, because people take their work home or they conceal, or they conceal evidence in the home or other places, they can search the residences of members of staff. So not only can they show up at the firm's headquarters, but they can show up at people's houses. Okay? To do this, typically they need a special decision. What they do is they get a decision from the commission that then is taken to a court of competent jurisdiction, and they get a search warrant under national law to do this. Okay? So, the information is gathered. Then what happens is once the commission has sufficient information, it sends to everybody involved a statement of objections. Okay? This lists out, or this in effect details, stipulates the commission's case. Okay? Once the statement of objections has been received, there's an opportunity for a hearing before a hearing officer who's a commission employee. The hearing officer will listen to the case, okay? It's a protracted process, can last well, not years, but intermittently, take time over a period of months or years, okay? At the end of this process, the hearing officer will prepare a decision, a recommendation for a decision, which actually turns into a decision in practice. And the decision will also have, if there is a breach, will also stipulate a fine. This decision then will be presented to the College of Commissioners, who will take it as a decision, and then it will become binding or effective on the undertakings involved. The undertakings can then appeal this to the Court of First Instance, the General Court, and then in turn there's a second avenue of appeal to the ECJ. Most initial decisions are appealed because if it goes down a bit, it more than covers the legal costs. Okay. The EU process is quite similar. CMA gathers the information, presents the case, issues a statement of objections, holds a hearing, issues a decision. You don't like the decision, you can appeal to the Competition Appeal Tribunal, and then from thence to the Court of Appeal, and then possibly to the Supreme Court if they'll listen to you. Going back to the EU, setting fines. Commission has a set of guidelines on how fines are set. There's a legal maximum of 10% of the undertaking's total turnover of the previous year. In other words, how much sort of the gross revenue of the undertaking. You want to look through the setting of fines, this document. Okay, you'll see there's a basic amount, sales in relation to the affected product. You come up with a basic amount looking at the nature, market share, scope of the cartel. So what kind of cartel was it? How much of the market did this undertaking involve? How big geographic scope of the cartel? Typically, in terms of the nature, horizontal price fixing, market sharing, and output quotas are the most serious. Okay. Then another set of adjustments to the basic amount. Commission makes another set of adjustments looking at aggravating circumstance. Are we dealing with a 2-time or a 3-time offender? Mitigating circumstance, the cooperation, so on and so forth. Issues of deterrence. Then you apply a legal maximum. That's to say, does the amount exceed 10% of the undertaking's turnover? If so, you reduce it to that amount. Then you apply the leniency notice, which I'll get to in a minute, and then you look at ability to pay. Public sanctions in the EU, and that's the most recent figure. I checked them this morning. Look quite big, right? Last year to the 27th of September. Reason there's been nothing after the 27th of September. 1.4 billion euros. Looks like a large amount of money. Okay. Reason it hasn't been there is now the Commission seems to be changing focus to 102 violations, which we'll get to. Okay. So it looks like a lot of money, okay, and they can appear to be substantial. The largest in the cartel is 3.some billion, 3.8 billion in the trucks cartel, and Dalmer was a member of that cartel, was fined for cartel behavior over 1 billion. Now, in comparison, some of the 102 fines are even bigger. Just talk to Microsoft and Google about that, okay? Which we'll get to in a minute. Now that money, you're asking where does it go? It goes into the general budget of the EU. Okay, so it's less money that the EU taxpayers have to pay. Okay, now we have 5 minutes. I can cover this in 5 minutes. Are the fines large enough? Okay, we're just gonna start this and I'll continue with this point on Monday, okay? So very interesting article by Gary Becker. Okay, this is the law and economics approach. So Gary Becker is a University of Chicago school economist. Okay, and his insight is that if you have any activity, each activity has its costs and its benefits. If you wish to discourage an activity, you ensure that its costs exceed the benefit. Okay? A rational agent will not engage in activity that's more costly than the expected return. Okay, we can put this aside for a minute, how generally applicable this is. But surely one can think that if there is a rational agent, it would be a firm or a company trying to maximize its profits or maximize its position on the market. So you would think, if anything, a rational firm or undertaking would play by these rules. Okay, Becker's insight is if the cost of the activity exceeds the benefit of the activity, then people will not engage in the activity. And for Becker, crime was the insight. Okay. A rational criminal, to the extent that criminals are rational, will not engage in criminal activity if the cost of that activity exceeds the benefits. Becker came to this insight one day when he was trying to park his vehicle. He was running late for an appointment. Okay. And he couldn't find a legal parking spot, so he thought about parking illegally and ran this through his mind. Okay. So the cost of crime is the probability of detection multiplied by the cost of the punishment. Okay, not all criminals are apprehended, right? We know that. So, suppose you're in Becker's position, a parking fine of 50 pounds, and the probability of being caught, in other words, having the parking warden slap a ticket on it, is only 10%. That means 9 times out of 10 you pay nothing. 1 time out of 10 you pay 50 pounds. Sum that up, divide them out. Each incident of illegal parking is only going to cost you $5. Now, if it's in your interest, if it's more beneficial than 5 pounds to park for you, it's a very important appointment or something like that, you're going to park illegally, right? This is why parking works so well. Nobody gets morally horrified over illegal parking. Okay, right? It's not like murder or theft or something like that, where people get morally horrified. Okay, so the cost of the illegal parking is 5 pounds. Now, you can apply this to cartel behavior. Okay, and therefore ask yourself, is the fine that results from being caught sufficiently high to deter cartel activity and the profits that one can make? Okay, now I'm going to stop here. I'll go over these numbers on Monday. But there's a very good case, one can make quite a strong case, that these fines are insufficient. Okay? And that they in fact serve as license fees. Okay? But paradoxically, if you increase the fines, you may well put companies out of business. Okay? So taken together, that may well be a strong argument for personal sanctions, criminal sanctions. Okay. So we'll look at that when we'll go over the slides of between now and Monday. That's there, and then we'll do that briefly at the beginning of class on Monday, and then we'll turn to vertical agreements. Okay?
You said if you report to the EU, you're the first one to report
Yeah.
you can essentially be waived off on that.
Exactly.
But does the EU, in a sense, look at intention, or is it just the first one? For example, if two people on the same day both reported, what is it, who did it first?
Who reports first?
So it doesn't look at intention, they're both feel they
First, okay. Now, if you're, we'll get to the leniency notice on Monday. Okay, have a look at the leniency notice. Okay. They'll also point out that, for instance, the situation has, if you're an instigator or you're an enforcer, then there's no problems getting leniency. But it's literally a race. It used to be a race to the last team. Now it's not a race to the first team. Okay. And what that does is that it encourages instability within itself. If there's already suspicion and distrust, that's why you have the trial all mediated.
It's not like we all should do it, we're all mediated. There's only the first.
And then the first gets 100%, second and third gets less. Yeah. So the whole thing is to exploit distrust in the cartel, incentivizing.
You just want to keep walking the boat, essentially.
Yeah.
I have another class I have to get to, so I'm going to leave my things and then I'm going to come to your office.
At what time?
Like now.
Oh, you're
But I'm going to come to your
I
office
see.
in like a couple of minutes.
Oh, I see what you're doing. You want to talk to me now, and then go to your other class.
No, I'm going to go to another class, leave my things, and tell my lecturer that I'm going to be late, and then
Okay, come back. Okay.
Yeah, then I'm going to come back here.
Class is here, is what you're saying. Class is here, is what you're saying.
No, it's in the in the building.
Okay.
So I can meet you at your office. Is
Yeah.
that okay?
Yeah.
Is that okay?
Yeah. So okay, you're going to go there and then come back. Got it now.
Yeah.
Okay. I didn't. Yeah. I'm not in my office. I'm just down getting a cup of coffee.
Okay.
Hello ladies, you alright? Yes, good, how are you? Not so bad, thank you very much. Even smaller in number so far. 2 of you waiting. We shall see if we get some more takers.